Well, thank you very much indeed. I wish Sonia was giving this lecture because I can testify that she is a most amazing speaker who can captivate an audience, and I'm going to be really dull. But I'll try and give myself some lubrication. Well, as Sonia mentioned, the air this year is full of women's rights. And today I want to look at how well the UK is doing when judged against international standards of women's rights. And the answer is not as well as you might think. Of course, we are celebrating 100 years since women got the vote last year. This year, 100 years since women got the right to join the professions and take public office. But how far have we really come in those 100 years? Currently, 32% of the members of the House of Commons are women. But it was only in the 1990s that the percentage crept into double figures. Until the 1997 election, it was under 10%, and had for many years after the Second World War hovered at around 4%. So it leaped to 18% in 1997, 22% in 2010, and now to over 30%. But in 2016, for the first time, there were as many women MPs ever as there were men MPs then in the House of Commons. It's quite shocking, isn't it? Much the same pattern can be seen in the judiciary and the magistracy. Actually, the magistracy is a bit different. Currently, women make up roughly a quarter of the High Court, the Court of Appeal, and the Supreme Court. Percentages are higher lower down the judicial hierarchy one goes, from the circuit to the district to the tribunal benches. But there has been remarkable progress over the past 2 decades. It took the powers that be a long time to appoint the first women professional judges, a metropolitan stipendiary magistrate in 1945, a recorder in 1956, a county court judge in 1962, and a high court judge in 1965. And when I was appointed in 1994, I was only the 10th ever woman to be a high court judge. Progress in appointing women as lay magistrates was much quicker. They'd reached around 20% by 1948, and by 2018, they were 55%. Does that tell us that it's easier for women to get appointed to voluntary unpaid roles than it is for them to take the well-paid jobs from the men? There is also some correlation between the presence, or at least a temporal one, between the presence of women in Parliament and in the law and the advancement of women's rights generally. I've chronicled elsewhere in a lecture I gave in Birmingham University last November the improvements in the legal status of women which have taken place over the last century, but mainly since the 1960s. The advent of gender-neutral rights and remedies in family law, the advent in practice and within limits of no-fault divorce, the improvement in the remedies available to redress the disadvantage suffered by homemaking spouses, the equalisation of parental rights and authority. It is shocking to consider, just as an aside, my daughter was born in 1973. It was only in 1972 that I gained equal rights and authority with my husband in relation to her upbringing. Yes, let's be shocked. The advent of better remedies for domestic violence and abuse, and the availability of alternative housing for the victims, at least if they had children, the Equal Pay and Sex Discrimination Acts, and a great deal more. But things are not yet perfect. The focus of attention has moved on from those early preoccupations with basic equality rights at home and at work to other causes for concern. And if things are not yet perfect in this country, how much less perfect must they be in many other countries in the world where women are not as fortunate as we are here? Some random facts about the status of women's rights in the world, supplied by Womankind Worldwide, can illustrate the point. Globally, women make up under 24% of parliamentarians, and in 2016, 38 countries had under 10%, 4 of them had none. In most countries, women earn on average 60 to 75% of male incomes. In only 18 out of 173 countries is there specific legislation combating sexual harassment in public places. women spend twice to 10 times more time a day on unpaid care work, looking after children, the elderly and the unwell, than men do. Over 700 million women alive today were married before they were 18, and of them, 250 million were married before they were 15. At least 200 million girls and women alive today have undergone female genital mutilation. 38% of all murdered women are killed by their partner. Globally, it is estimated that almost half were killed by a partner or relative, whereas the equivalent figure for men is less than 6%. In the European Union, women with a disability or health problem are twice as likely to experience violence from a partner. Hardly any of the aid to conflict-affected states targets gender equality or goes to women's equality organisations. And then finally, women are extremely underrepresented in peace processes, and yet when they are involved, the probability of a peace agreement lasting at least 2 years is increased by 20%. So these are shocking facts, which persist despite more than half a century of international instruments at least paying lip service to gender equality. After all, the grand old daddy of them all, did I say daddy? Yeah, well, never mind, is the United Nations Charter. Article 1 declares its purposes to include promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinction as to race, sex, language, or religion. Then, of course, in 1948, there was the Universal Declaration of Human Rights. I think that might claim to some maternity there, Eleanor Roosevelt. And its preamble affirms faith in the equal rights of men and women. Article 1 declares that all human beings are born free and equal in dignity and rights, and Article 2 that everyone is entitled to all the rights and freedoms in the Declaration without distinction as to, among other things, sex. It is said that the United Nations Commission on the Status of Women played a role in ensuring gender-neutral language in the Declaration. If that is so, perhaps it's a shame that they didn't find a better word than brotherhood in the otherwise very moving second sentence of Article 1, which says that everyone is endowed with reason and conscience and should act towards one another in a spirit of brotherhood. It's not true, of course, but it's a good aspiration. In retrospect, it's also unfortunate that in 1951, the Convention relating to the status of refugees didn't include sex among the grounds upon which there might be a well-founded fear of persecution in the asylum seeker's home country. In this country, it took the House of Lords to decide that gender-based violence and female genital mutilation could nonetheless amount to persecution on the ground of membership of a particular social group. The Universal Declaration, of course, wasn't a binding instrument, and it took until 1966 to translate its obligations into the International Covenants on Civil and Political Rights and on Economic, Social and Cultural Rights. Hilary Charlesworth has described some of the criticisms of general international human rights instruments from a feminist perspective. Firstly, she says, rights are defined with reference to men's lives and public spheres of activities. Women's lives, often associated with private realms of home and family, don't sit easily with standard accounts of rights. Issues of particular importance for women, such as sexual violence, are not covered. Secondly, she says, international law focuses on states as the primary violators of human rights, but non-state actors, including family members, are more likely to threaten women's human rights. And thirdly, notions of equality and non-discrimination are premised on male-defined terms, requiring women to be treated in the same way as a similarly situated man, without recognising the effects of structural discrimination against women. The fundamental problem for women is not simply being treated less favourably than men. Women are in an inferior position because they lack economic, social and political power in both the public and private worlds. Well, in 1965, a start was made in devising instruments to meet the needs of particular groups. That was the International Convention on the Elimination of All Forms of Racial Discrimination. So was there a need for a specialist human rights instrument which addressed the position of women? Well, there was. The Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, was adopted in 1979. This is a very broad scope, transcending the traditional divide between civil and political rights and socio-economic rights. It tries to achieve a blend of formal equality with men, equality of opportunity, and substantive equality, equality of outcome. It tries to accommodate both the universality of human rights and the recognition that in some respects, women's lives are different from men's lives and require particular treatment. In the preamble, the Convention acknowledges that the extensive discrimination against women continues to exist. Discrimination is defined in Article 1 as any distinction, exclusion, or restriction made on the basis of sex in the political, economic, social, cultural, civil, or any other fields. And states parties are required by Article 3 to take all appropriate measures, including legislation, to ensure the full development and advancement of women for the purpose of guaranteeing them the exercise and enjoyment of human rights and fundamental freedoms on a basis of equality with men. But the fundamental underlying problems lie in deeply entrenched social and cultural views and practices which ascribe an inferior position to women, coupled with a lack of respect for the vital role they play in bearing and rearing the next generations. Article 5 of CEDAW attempts to tackle these problems. It requires states parties to take all appropriate measures, A, to modify the social and cultural patterns of conduct of men and women, with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes, or on stereotyped roles for men and women, and B, to ensure that family education includes a proper understanding of maternity as a social function and the recognition of the common responsibility of men and women in the upbringing and development of their children, it being understood that the interest of the children is the primordial consideration in all cases. So then it goes on to deal with civil rights and legal status of women in detail. They should have equal rights to vote, to participate in the formulation of government policy, to hold public office and perform public functions, to participate in non-governmental organisations and what we now call civil society, and to represent their governments at international level. The Convention on the Nationality of Married Women, which had been adopted in 1957, is integrated to ensure that women's right to nationality is not dependent on their husband's nationality, and that they have equal rights with respect to the nationality of their children, something we're still taking time to work through. They must have equal rights to education and access to the same curricula as men. Article 10C seeks the elimination of any stereotyped concept of the roles of men and women in all forms of education by encouraging co-education and the revision of textbooks, school programs, and teaching methods. They're also entitled to equal rights in employment, including not to be discriminated against at work on the ground of pregnancy or maternity, and in economic and social activities. Article 16 asserts the equal rights and obligations of women and men in relation to their choice of spouse, parenthood, personal rights, and command over property. Article 16 also directs attention to reproductive rights. Women must have the same rights to decide freely and responsibly on the number and spacing of their children, and to have access to the information, education, and means to enable them to exercise those rights. Throughout the Convention, the theme of maternity as a social function requiring strong protection can be seen, including the assertion that special measures aimed at protecting maternity are encouraged and should not be considered discriminatory. Although shot through with requirements that women should enjoy equal status with men in all things, the Convention does not in so many words acknowledge that gender-based violence is a form of discrimination against women. That had to come later in the CEDAW Committee's General Recommendation number 19 in 1992. Now, it might be thought that, With all the reforms which took place in the 1970s, long before the convention arrived, the UK was doing pretty well. Nevertheless, the CEDAW Committee has found plenty of causes for concern in its most recent reports about the UK. In its concluding observations on the 7th report from the UK in 2013, the committee was critical of the introduction of the Legal Aid, Sentencing and Punishment of Offenders Act, LASPO, and its impact on women's access to justice. This criticism was deployed in many challenges to the Act, particularly in the successful case brought by Rights of Women against the Lord Chancellor. The Court of Appeal held that the requirement that written evidence of domestic abuse be dated not more than 24 months before an application for legal aid was not rationally connected to the purpose of the legislation. This was, as the court found, partly to withdraw civil legal services from certain categories of case in order to save money, but also to make such services available, perhaps not to the entire membership of the most deserving categories of case, such as victims of domestic violence, but at any rate to the great majority of persons in the most deserving categories. So this conclusion led the Ministry of Justice to establish a working party, which resulted in a widening of the regulations to allow victims more easily to access legal aid. This process was aided by a requirement for an interim report to the CEDAW Committee and a further determination directing the UK government to make urgent improvement to areas of non-compliance. Now, in March of this year, the committee issued its concluding observations on the 8th periodical report of the UK. And this welcomes various initiatives in the field of domestic violence in particular, and the measures adopted to facilitate access to civil legal aid for victims of domestic violence and child abuse. It also notes that the introduction of fees for employment tribunal applications, which had previously been found to be of concern, have been declared unlawful by the Supreme Court in the Unison case. However, it remained concerned that cuts to legal aid, as well as strict criteria for gaining access to it under LASPO, quote, continue to have a negative effect upon women's access to justice and effective remedies in areas such as family, housing, immigration, and welfare benefits law, end quote. Committee has a number of other concerns. One was the disproportionately negative impact of austerity measures on women, who constitute the vast majority of single parents and are more likely to be engaged in informal, temporary, or precarious forms of employment. These measures included cuts to funding to organisations which provide services to women and in social care services which increase the burden on primary carers who are disproportionately women. The committee doesn't specifically mention the benefit cap, which has so much troubled the Supreme Court recently. Perhaps that's why they don't mention it. It might have put their faith in us. Oh dear, oh dear. But it does single out for particular concern the payment of universal credit into a single bank account, which risks depriving women in abusive relationships of the ability to gain access to necessary funds and trapping them in situations of poverty and violence. It is also deeply concerned about the introduction of a two-child credit limit, except in certain circumstances such as rape, which has a perverse and disproportionate impact on women. The increase in state pension age for women was also contributing to poverty, homelessness and financial hardship among the women affected. Another concern is Brexit, which, in the committee's view, could, in the absence of comprehensive measures to empower women and national legislation incorporating the provisions of the Convention, lead to a retrogression in the protection of women's rights. Women might also be disproportionately affected by the negative economic impact of Brexit and the loss of funding from the European Union for specialist programmes and services for women and girls. Yet more concerns related to modern slavery and trafficking. Reports that increasing numbers of women were turning to prostitution due to poverty, the findings of the House of Commons Women and Equalities Committee on the prevalence of sexual harassment of girls in schools, and on the prevalence of sexual harassment in the workplace, the concentration of women in lower-paying positions in all occupational sectors and in lower-paying occupational sectors, the overrepresentation of women in informal, temporary or precarious forms of employment, including 0 hours contracts, the underrepresentation of women on corporate boards and in executive positions, and the continued underrepresentation of women in public and political life, particularly of black, Asian and minority ethnic women and women with disabilities. Wow, that's quite a list, isn't it? Let's try not to be too downhearted. Running also throughout the document is a concern that the absence of a functioning government in Northern Ireland since January 2017 has led to gaps in legislation and policy to ensure the effective protection of women there. Specifically, the Equality Act 2010 doesn't apply in Northern Ireland. The laws to protect women from all forms of gender-based violence are inadequate. They are particularly underrepresented in political and public life, and it recommends the use of gender quotas, which is actually allowed in Northern Ireland. Mandatory pay gap reporting has not yet been brought into force there, and childcare costs remain excessive. The CEDAW committee had, of course, produced a special report in 2018, finding that Northern Ireland's abortion law and practice seriously violated the Convention in a number of respects. It was unimpressed by the UK government's response that abortion is a devolved matter. The CEDAW committee points out that in international law, it's for the United Kingdom to fulfil its obligations under the Convention, not to pass them off to some other part of the United Kingdom. And that responsibility is recognised in the Good Friday Agreement. All in all, this year's report is an interesting document. No doubt the government would not accept that all of its criticisms are valid. However, it does illustrate how far, despite all the advances in women's rights which have taken place over the last half-century, the UK still falls short of what, in the eyes of the international community at least, is required to eliminate all forms of discrimination against women. However, even if we were to agree with the committee, there's very little that we in the courts can do about this. Despite the committee's urgings, CEDAW has not yet been incorporated into UK law. In fact, it probably never will be, because it's the kind of treaty, like the UN Convention on the Rights of the Child, which the UK considers too vague and aspirational to translate into directly binding legal obligations. Sometimes, as with Article 3.1 of the UN Convention on the Rights of the Child, there are statutory provisions which are designed to reflect it, although they don't say so in so many words. Sometimes it's possible to take note of international law obligations as part of the interpretation and application of the rights protected by the European Convention. The Supreme Court now accepts, at least I think it does, that whether the authorities have complied with Article 3.1 and treated the best interests of the children involved in their decisions as relevant to whether discrimination in the enjoyment of Convention rights can be justified, yes, it does accept that. It's done so in both of the benefit cap cases and in one or two others as well. So I think that's done and dusted. CEDAW, however, has fared less well. In the case of A, the Secretary of State for Work and Pensions, this was one of the many cases which were grouped together to challenge what we are obliged to call the removal of the spare room subsidy. That's its official title. You all know it as the bedroom tax. One of those cases involved a woman victim of severe domestic violence who complained that it was unjustified sex discrimination to impose the bedroom tax on her specially adapted sanctuary home. This was a home, she was so much under threat of very severe domestic violence that she had been given a council house which had been specially adapted with all sorts of alarms and security features and a special sanctuary room where she could retreat with her son if, despite that, her aggressor broke into it, and direct access, obviously, to the police station. Well, of course, the only people living there were her and her son, and what had they chosen to adapt? A 3-bedroomed house. So she didn't qualify for that house. She didn't need the extra bedroom, but of course what she did need was to stay there. And I thought that this was unjustified sex discrimination. Unfortunately, I could only persuade Lord Carnwath to agree with me. There we go. Another case that we have had, A and B against the Secretary of State for Health. The majority was not persuaded that the international law materials, principally CEDAW, were relevant to deciding whether the discrimination against women from Northern Ireland in not funding abortion services for them in England could be justified. The appellants placed particular emphasis on Article 12 and the obligation for states to take appropriate measures to eliminate discrimination against women in the field of healthcare, including family planning and services in connection with pregnancy. They also relied on General Comment number 22 in 2016 of the Committee on Economic, Social and Cultural Rights that reproductive health care is intimately linked to civil and political rights, underpinning the physical and mental integrity of individuals and their autonomy, such as the rights to life, liberty and security of person. Denial of abortion often leads to maternal mortality and morbidity, which in turn constitutes a violation of the right to life or security, said the committee. However, the majority of the court held that this material, quote, only adds background colour to the inquiry into fair balance under the European Convention, a material, quote, of a far more vivid hue, end quote, will be needed to overcome the minister's legitimate concerns of maintaining the provision of healthcare services on a territorial basis and respecting the competence of the Northern Ireland legislature over abortion law in that territory. And that was another case in which I failed to persuade the majority to my point of view. It's all right. I mostly do. But it's quite interesting that it's in the field of women's rights that I least often do. Among the CEDAW Committee's recommendations is that the UK should ratify the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence, the Istanbul Convention, which came into force in April 2014. Its aim is to build on existing international obligations to design a comprehensive framework, policies and measures for the protection of and assistance to all victims of violence against women and domestic violence. You note the phraseology, violence against women and domestic violence. Behind it lies a deep division of opinion about whether domestic violence is a gender-based problem. Lisa Gormley reports that during the negotiations, some states still identified domestic violence as an issue that affected as many men as women, albeit without any studies to support this belief. But this issue went to the heart of the substance of the treaty, and a compromise was found in the words of Article 2 that 1, this convention shall apply to all forms of violence against women, including domestic violence, which affects women disproportionately. And 2, parties are encouraged to apply this convention to all forms of domestic violence. Parties shall pay particular attention to women victims of gender-based violence in implementing the provisions of this convention. So, there is lots to welcome in the Istanbul Convention. Some progressive milestones identified by Lisa Gormley. Firstly, the inclusion for the first time in binding treaty law of sexual orientation and gender identity as impermissible grounds for discrimination. As we know, the European Court has long recognised these as other status within the meaning of Article 14, but including it in the express list of impermissible grounds is new. Secondly, requiring that incidents of domestic violence are taken into account in deciding custody and visitation rights, and that the exercise of such rights does not jeopardise the rights and safety of the victim or children. In other words, the parental rights of fathers mustn't trump the safety of victims or children. Thirdly, contrary to the views of those who regarded these as more minor or likely to lead to unfair penalising of men, the requirement to criminalise psychological violence, the intentional conduct of seriously impairing a person's psychological integrity through coercion or threats, stalking, the intentional conduct of repeatedly engaging in threatening conduct directed at another person, causing her or him to fear for her or his safety. And sexual harassment, any form of unwanted verbal, non-verbal, or physical conduct of a sexual nature with the purpose or effect of violating the dignity of a person, in particular when creating an intimidating, hostile, degrading, humiliating, or offensive environment. Although, whereas the first two had to be criminalised, sexual harassment could be the subject of criminal or other legal sanction. Fourthly, the definition of rape and sexual violence, based on the International Criminal Court's definition, which encompasses a variety of acts of penetration and doesn't require physical force. Fifthly, the requirement that in any civil or criminal proceedings, evidence relating to the previous sexual history or conduct of victims may only be introduced if it is relevant and necessary. Sixthly, the insistence that culture, custom, religion, tradition, or so-called honour are not to be regarded as justification for acts of violence. This is drawn widely enough to cover traditional ideas about provocation as a partial defence to murder for killing an adulterous spouse. 7. There are practical common sense provisions allowing for emergency barring orders and immediate restraining orders without undue financial or administrative burdens. Then 8. The requirement that gender-based violence against women be recognised as persecution within the meaning of the Refugee Convention and as a form of serious harm giving rise to complementary or subsidiary protection, together with gender-sensitive reception procedures and support services. Well, I said we have done that, but it took the House of Lords to do it. And then lastly, victims whose residence depends on a spouse or partner should have the opportunity of establishing their own residence status and must be offered a renewable residence permit where their stay is necessary owing to their personal circumstances or for the purpose of assisting investigation or prosecution. So lots of good things in the Istanbul Convention, but of course the UK hasn't yet ratified it. But it is taking steps to do it. It consulted earlier this year on a domestic abuse bill which was designed to introduce things, some of the remedies which are in the Convention. And these detailed and intensely practical requirements are surely to be welcomed. Lisa Gormley expects that it will have an immediate transformative effect in causing more survivors to make known their experience, thereby improving the knowledge base for implementing the Convention. The requirement on states to engage positively with civil society organisations should improve its effectiveness. So she concludes that the Convention provides an engine for change and may lead to a universal convention. This optimism echoes that of Judith Resnick, who has argued that the CEDAW reporting mechanism, quote, undermines not only inequalities among women and men, but also traditional hierarchies in international law. Quote, referencing the composition of the committee, she comments that this diverse set of persons, hailing from poor as well as powerful countries, is positioned to interrogate high-level officials from all 187 signatories to CEDAW. However, as she also points out, the committee has the competence to make demands, but not to impose sanctions. The protection of women's rights worldwide is precarious. And evidence of this can be found in the many broad reservations to the requirements of CEDAW, mostly based on assertions of culture or religion. If you go through it, you can see those countries which have said, well, we won't do this and we won't do that because it's contrary to our religion. Israel, for example, reserves its position insofar as the laws of personal status binding on the several religious communities in Israel do not conform to the Convention, and as to the appointment of women to be judges in religious courts, where this is not allowed by the religion in question. This takes virtually the whole of family law out of the requirement for equal treatment, because it's all in religious courts in Israel. Hilary Charlesworth also points out that it is striking that the concept of culture is much more frequently invoked in the context of women's rights than in any other. This would be unacceptable if racial discrimination were in issue. She quotes Arati Rao, who describes the notion of culture favoured by international actors as, quote, a falsely rigid, ahistorical, selectively chosen set of self-justificatory texts and practices whose patent partiality raises the question of exactly whose interests are being served and who comes out on top." End quote. That's one reason why it matters so much that so few women are engaged in peace processes in conflicts such as those in Iraq and Afghanistan. And UN Women decided not to hold another conference on women in 2015, 20 years after the Beijing Declaration and Programme for Action, for fear that the gains made since then might be put at risk. So the fear is that although we have made a lot of progress, there's still a lot to do. There is a real risk that the progress that has been made might be rowed back from. Well, there are still a few more reasons to be cheerful. The majority of members of the cabinet in Spain is now female. Women in Saudi Arabia may now drive. Voters in Ireland repealed the 8th Amendment to Ireland's constitution and approved a scheme to legalise abortion. Women, especially women of colour, were voted in record numbers in the House of Representatives in the US midterm elections. Jacinda Ardern became the first elected head of state to take maternity leave in office. Actually, I'm not sure she's head of state, she's head of government, I think. But nevertheless, probably the first elected head of government to take maternity leave in office. One of the joint winners of the Nobel Peace Prize was Nadia Murad, an Iraqi member of the Yazidi community who was captured by ISIS and now works for victims of sex trafficking. And the Me Too movement has started an international conversation about harassment and sexual assault. For example, CARE International is campaigning for the International Labour Organization to adopt a new global treaty to tackle the sexual harassment of women in the workplace in all corners of the world. So yes, of course there are reasons to be cheerful. The suffragette slogan was "deeds, not words," but sometimes words, especially those in international treaties adopted across the world, can help. Thank you.